Darren Heitner, who is seems to be on top of this down in the state of Florida, is kind enough to stop by here on Off the Bench, ESPN New Orleans, Baton Rouge, and Alexandria. Darren, good morning. Thank you for your time.
Good morning.
So where would you start with the Zion ruling from yesterday? If you were explaining it to a couple of mindless radio hosts here that have no idea what's going on.
Put some general studies majors. Thank you.
I guess how much time do we have? As brief as possible, there's two different lawsuits that are pending that revolve around Zion Williamson and Zion Williamson's former marketing agents. There's a federal court case pending in North Carolina, which was actually brought first, and that was brought by Zion Williamson against his former marketing agents with the intention to have the court declare that their marketing agreement is null and void. And then you actually had the marketing agents file an action in state court in Florida, really based on the same set of facts, but they are seeking compensation. They're seeking roughly $100 million of relief against Zion Williamson under the assumption that the agreement is valid. So really, the question that both courts are tasked to answer is primarily, is there or was there a valid marketing contract between the prior agents, who are no longer representing Zion since signed with Creative Artists Agency, and Zion Williamson. And what's so interesting about the decision yesterday, and the decision yesterday came in state court in Florida. Remember, that's the case that was filed after the case was initiated in federal court in North Carolina. What's so interesting about it is it really goes against prior precedent. Precedent established in the state of Florida and through the courts of appeal basically says if there's a prior filed case that revolves around the core set of facts that are the same in both cases, then really the second case should be stayed. It should be tabled until determinations are made in the first filed case. And remember, that's the case that was filed in North Carolina.
Yeah.
But the judge yesterday basically set that aside and said, there's important issues that need to be decided. I'm not willing to stay the case. And Zion, you need to answer these interrogatories, these questions, and requests for admissions revolving around, as you mentioned, whether or not he or his family received any improper benefits from Duke, from Nike, from Adidas in order to attend Duke, and therefore shed his student-athlete eligibility, which is somewhat a part of these disputes.
Darren, so then I think the question on everybody's minds are in here is how realistic do you think it is that Zion will end up taking the stand under oath and have to answer these questions?
So taking the stand under oath, that would obviously be something that would be if this case goes to a trial. One thing that was discussed yesterday in the roughly hour-long hearing is whether the parties would agree for Zion Williamson to be deposed, but that's not even on the table yet. Right now, we're just talking about answers to written questions.
Okay.
So how likely is it that he has to answer those questions?
Yes.
I still say slim, because what I expect to happen now is Zion Williamson's attorneys in the state court case in Florida will now seek to appeal that lower court's ruling. That was not a court of appeals that made the decision yesterday. That was actually the lower tribunal. That was a state court. So now I expect those attorneys to file an appeal with the Third Circuit Court of Appeals in the state. And my expectation is based on precedent that the appellate court will actually overrule the trial court's decision. In the meantime, while that appeal is pending, I do not expect any responses to be provided. And there has not yet been a written order. There was only an oral order yesterday. So even if, let's say, there was no appeal, we're not exactly sure how long Zion would have to answer it. It certainly wouldn't be within the next few days.
Darren Heitner joining us here, ESPN Baton Rouge, New Orleans, and Alexandria. He's on Twitter at Darren Heitner. I know that you are in the state of Florida. You are a professor at the University of Florida where you teach sports law, but do you have any idea or thought on what could come of the case in North Carolina?
I do. I am a former agent myself. I do a lot of legal work for a variety of agents in pretty much every professional sport, and I'm very familiar with the Uniform Athlete Agent Act, which is a resolution that was passed years ago by federal Congress, basically imploring all the different states to adopt their own athlete agent laws. And North Carolina is one of them that did. And the law in the state of North Carolina sets forth many requirements for agents to operate within the borders of that state. One of those requirements is to be licensed. Another one is in any agreement with an athlete who still has eligibility, there needs to be a strong disclosure. In fact, you just copy and paste the words from the act. The problem for the prior agents in this case, or in these cases, is that, one, the agents were not licensed in the state of North Carolina, where Zion was participating as a college athlete. And two, the marketing agreement did not contain that specific language, which is a requirement. And if you look at the statute in the state of North Carolina, it explicitly states that if you are not licensed or you do not include that language, the underlying contract is null and void. So I think more likely than not, this is a case that Zion Williamson will win against the former marketing agents. Why is now his eligibility such an important issue? Well, because the phrase student athlete is actually defined in the athlete agent law in North Carolina. And it says it's somebody who engages in, is eligible to engage in, or may be eligible in the future to engage in intercollegiate sport. So basically what the former agents are saying is if he accepted improper benefits, then he wasn't a student athlete, and thus this law would not apply. I think the biggest problem is it says "or" in that act, and so he did engage in intercollegiate sport. I think it's a slam dunk case for Zion Williamson. The weird thing now is that the state court in Florida doesn't seem to be willing to just let the federal court in North Carolina have the case play out. And so, sometimes you get quirky decisions like this.
Talking to Darren Heitner, sports law for Florida. Let's ask the real questions now, Darren. Is it more likely than not that Dan Mullen in Florida will finally get over the hump and beat Georgia? I feel like it's y'all's year.
I think it's more likely than Zion Williamson winning his case. I mean, come on, let's be honest here.
Is there any shot that Coach K has to answer any question under oath?
Less than a 1%.
Yeah, come on,
Darren,
come on, too big. You can't get him.
Hey, Darren, this is great stuff, man. I was looking at your sports agent blog, which you can read at if you're listening to this. The blog is on Twitter at Sports Agent Blog. He also founded Heitner Legal, as we said, coming in, and he's a professor of sports law over at the University of Florida. Excellent insight. Thank you for the time this morning, Darren.
Have a great day.
You got it. There he is, Darren Heitner, checking in from Gainesville this morning, or Fort Lauderdale, checking in this morning from Fort Lauderdale.